Yeah. So, to everyone in the chat, some background on Lai. Lai King Hum founded the Hum Law Firm in 2014, and they focus on workplace law, human rights, professional regulation, and litigation. Her team is made up of 4 lawyers, and their clients include those in education, healthcare, hospitality, and lots of others. Lai is actually one of the 3 counsel in the Discrimination and Harassment Council program. She has held roles as past chair of the Roundtable of Diversity Associations and past president of the Federation of Asian Canadian Lawyers. Lai is also director of Up With Women and a trustee with the CPAC Foundation. All right, so I'll let you take it away. And I will also come on at the end of the session to do an outro for you. Okay?
Okay, thank you. Thank you, Jessie. Now, I'm sharing my PowerPoint. Jessie, is that up properly? Yes, it looks like it's up properly. Okay. So, because we're late, I'm going to try to power through this. But basically, this session is about workplace strategies in the wake of Waksdale and COVID-19. Really, it's about laying the groundwork to business recovery because many businesses are struggling. On the one hand, many businesses are struggling. Others are doing fine because they can do work remotely. And this really is addressed to those who may be having some issues and what things you can do to put you on the path to business recovery. So just some key dates to keep in mind. Business during the pandemic. You know, if you're working in HR or you're an employment lawyer, over the last year since the pandemic started with the lockdown in March, I think it was March 16 of last year, we're coming up to 1 year very shortly. There's been so many changes. So every few weeks at times, and certainly every few months, there were updates on employment matters, and I would be sending out email alerts to my employer clients. But these are some of the key dates to keep in mind. March 1, 2020 is what is called the start of the COVID-19 period, and this is the date that you would use for the purposes of the deemed infectious disease emergency leave, and which exempts which employees can use to go on leave for any COVID-19 related issues, but employers may also put people on temporary layoff or reduced hours of work or wage reductions, and are exempt from the ESA temporary layoff provisions. November 20 is the start of the Supporting Ontario's Recovery and Municipal Elections Act. I'll talk to you about that a bit later, just to highlight the date that it started. February 19, government announcement, very recent, of a launch of education campaigns to help businesses reopen safely. So again, steps towards recovery. And this has to do with health and safety pieces that are readily available on government websites, particularly the Ministry of Labor, Training and Skills. And for those of you who have been keeping track of the temporary layoff periods, again, the COVID-19 period suspended the temporary layoff periods under the ESA. The end of that period for now is July 3rd, 2021. That's been changed so many times. First it was September, then it was sometime in January. Now it's July 3, 2021, unless it's further extended again by the government. And for business recovery, I'm sure many of you are already aware of all the different government measures to assist business. Some of the ones that you might many businesses are taking advantage of, and I encourage you to, as a strategy to deal with temporary layoffs, is the Canada Emergency Wage Subsidy. That subsidy has been raised to 75% for the period between December 20 to 2020 to March 13, 2021. again, unless it's further extended. There's also the work sharing program and the Canada Emergency Rent Subsidy. The rent subsidy change is significant because the rent subsidy will now go directly to the renter rather than to the landlord, and the landlord does not have to approve before you apply for it. So quickly going to the next slide, really the top employment issues that I wanted to deal with was strategy, discussing the right to temporary layoff or reduce hours versus the risk of constructive dismissal claims. And I'll touch on that quickly later. The most significant thing that happened over the last year in employment law had nothing to do with COVID itself, but happened to land in the midst of COVID is a decision that came out of the Court of Appeal in June of 2020, which dramatically changed the employment law landscape. So I'll talk about that as well. And of course, safety issues. And the last topic, which I'll just touch on, is frustration of contract. Question mark. ESA temporary layoff versus common law constructive dismissal. As HR professionals, I'm sure you know, the presumption is employees are entitled to reasonable notice, common law reasonable notice if they're terminated, unless they have a contract that had a written contract that has termination clause that complies with the ESA and at least offers the minimum under the ESA. If you don't have a written contract that also has a layoff provision, a written layoff provision, you may not be able to temporarily lay off someone and be free of a risk of constructive dismissal claim. So that is something that your business has to take into consideration. If I don't have contracts that have a written temporary layoff provision, do I lay off? Is there a risk that my employees will come after me for constructive dismissal? Now, what I've seen in my practice is that many employees would prefer to keep a job that rather than go after their employer during this time. But as the pandemic extends, that may no longer be the case. So we have it's been since March 2020. We're coming up to a year. Will people continue to stay on layoff and not claim constructive dismissal? So those are some of the things that you have to consider. The extension of the suspension of the temporary layoff periods may be used to say that, well, no, it's not the same as the ESA temporary layoff. It's a layoff which arises from COVID. Maybe the employer could use a frustration argument that it's a result of government action and therefore they shouldn't be liable. But these have not been tested in court yet. It is a live issue, whether or not there is a risk of common law constructive dismissal claims. Now, this is the key thing that I wanted to touch on, the impact of that decision in June of 2020. So the Waksdale decision, if you're not already aware, is a decision about an employee who was terminated without cause. And the employee sued for wrongful dismissal and used and there was a termination clause in their contract. And they used the argument that the termination for cause provision violated the ESA, and therefore all the termination clauses, including the termination without cause, is void. At trial, the employer succeeded, but when the employee appealed further to the Court of Appeal, the Court of Appeal agreed that if one part of a termination clause is void, then all the entire termination clause is void. So instead of looking at the termination clause piecemeal, so part by part, they looked at it as a whole, and if any part of it fails, then all of it fails. it is a groundbreaking decision because all decisions prior to this did look at it piece by piece. So many people relied on termination without cause provision. And if that was valid, if it was well drafted and it complied with the ESA, then whatever limitations were imposed by that clause were valid. So you could put in a minimum ESA termination clause, and so long as that clause by itself is valid, then you were good to go. However, given this decision, all clauses have to be looked at. If any one of them is poorly drafted, does not comply with the ESA, then your entire termination clause is invalidated. I've seen comments from that about 90% of contracts may no longer be valid. So this is something that HR professionals really have to be aware of if you are not already, because I know that including myself and my other colleagues in employment law have been warning their clients about. So something that you need to do to be able to control the financial liabilities in the event that terminations do have to occur. And this also has a lot to do with what was anticipated when the contract was first entered into. So at the time that it was entered into, if the parties had considered that it would be an ESA minimum termination clause, it may no longer be the case when you terminate and you have not revised the contract. And of course, as HR professionals, you will also know that consideration will be required. So it's a very delicate situation. And when you do revise, you will have to have consideration for the revised contract. I really could talk forever about the Waksdale decision and what followed, but there's limited time here. So I'm going into slides on safety. Of course, safety is critical. There are significant liabilities now if businesses are not compliant. Section 22 orders of the Health Protection and Promotion Act provide medical officers of health significant powers to make orders where a business is not compliant. And of course, there's the usual employer obligations for health and safety. The workplace must be maintained in a healthy and safe manner in compliance with the Occupational Health and Safety Act. And of course, workplaces have to be free from discrimination and harassment that breaches the Human Rights Code. During the pandemic, we have had so many inquiries, both from employers and employees, we also serve employees, about what rights they have during COVID. And if they do have to go into work, what health and safety protocols have to be in place. So one thing is that we've noticed there is a lot of anxieties amongst workers about even going into the workplace. And we're all aware that governments are encouraging workplaces that can to have people working remotely. A big question is, well, can workers be forced to go into a workplace? And really the quick answer is yes. If the workplace is maintaining protocols in line with public health advisories, and two, if there are no issues of accommodation related to grounds under the Human Rights Code. So if there are childcare obligations, if there are medical issues, and then you may not be able to force someone to go back into work. But if there are none, and the employee may simply be anxious or a little bit concerned about going into a workplace because of the pandemic, you can force someone to go back in. Now, I have encouraged employers to be flexible. Mental health issues are on the rise. So to the extent that you absolutely to the extent that you can find someone else who is willing to go back into work to do that work, as opposed to the person who's concerned, then certainly go to the one who wants to go back in. However, if the person that you're wanting to go back to work is essential and there's no other person, then you can take that position. Of course, and I tell everyone, you have to keep monitoring the guidelines from all levels of government, especially with respect to public health, what health and safety protocols you need to take. We have just a few minutes left. There are liability protections for businesses so long as they have reasonably complied with health and safety measures. Again, keep track of what your obligations are, but that liability protection is not related to employment issues. So to the extent that it is a customer that is affected by may have contracted COVID when visiting your business, you may be protected. But if it's liability related to an employee, then it's still the Workplace Safety and Insurance Act that applies. Frustration of contract. So this is an interesting argument, and it has not been tested, to my knowledge, in court yet. But there has been a lot of discussion about whether or not an employer could claim frustration of contract when faced with a claim by an employee. So if you have temporarily laid off someone and they've been laid off for a long time, they claim that they have been constructively dismissed because you're employing them and they are entitled to their job. Well, frustration of contract is possible where the contractual relationship is impossible to perform because of some unforeseeable external event. And the question will be, well, is the pandemic something that is unforeseeable? And is, in fact, the contract impossible to perform? We haven't seen this tested in court yet. It's an interesting argument, and it may well be possible for the temporary layoff period, particularly where governments have mandated the shutdown. So if you're operating a restaurant and you cannot operate, that may be an argument to make, but it's something that we will have to see tested out in courts. So I really sped through that. This is my last slide, and really there are top tips. Be aware of amendments to the ESA, suspending temporary layoff provisions. Again, be strategic. You may want to take advantage of the Canada Employment Wages and supplement wages rather than lay off employees if you have experienced a reduction in business. Keep up to date on all assistance available to your business and, of course, all workplace health and safety protocols. And perhaps my top tip to manage liabilities, it's time to review your employment contracts and particularly the termination and temporary layoff provisions. And finally, I'm happy to answer questions. So if you want to email me and indicate that you heard me during this presentation at the Canadian Virtual HR Conference, I'm happy to engage. Thank you. And thank you, Jessie.
Hello, Lai. Hi.
Hi.
Just coming on to say thank you for the presentation and, for coming out. I know I sent you an email about this like basically last week, so it was quite short notice. I appreciate that. And, great coverage as always. It's good to hear like a perspective on HR from someone who is in the legal profession, right? So I did also want to let anyone in chat know, the Hum Law Firm, you guys have a COVID-19 hub, correct? So I'll actually link that just in the chat here because I find that it's a really useful resource for any HR professionals and, to stay updated on what they need to know basically about COVID-19 and legal developments related to that. So, and you know, Lai, like you said, to anyone in the chat, if you do want to contact Lai, if you have any questions, Lai, would you like me to post your email address in the chat here?
Yes, sure. I'm very good with email. I'm less so by phone.
Okay.
It's just harder to arrange.
Sounds good. Okay, there we go. So yeah, if anyone does have any questions for Lai, feel free to email her. You know, you might also want to connect with her on LinkedIn, and you know, connect that way. But overall, again, thanks for the presentation and thanks to everyone in the chat for coming out. We just have our, I believe we've got our panel at the end here. Yeah, so we've got our panel running on the main stage right now. If you want to head over there or head to the networking section. But overall, our sessions for today are done. So thanks so much.
Okay, thank you so much. Bye-bye.
Right. Bye-bye.